On 2 December 2024, the Secretary General reported to the Cairo Ministerial Conference, "Nothing justifies the collective punishment of the Palestinian people." Collective punishment is, of course, prohibited by Article 33 of the Fourth Geneva Convention. Secretary General continued, "Yet conditions for Palestinians in Gaza are appalling and apocalyptic. Malnutrition is rampant. Famine is imminent. Meanwhile, the health system has collapsed. What we are seeing may well amount to the gravest international crimes. In the face of the gigantic needs, humanitarian aid is outrageously being blocked. This flies in the face of the clear requirements under international humanitarian law to respect and to protect civilians and to ensure their essential needs are met. It defies numerous General Assembly and Security Council resolutions demanding a ceasefire and unhindered humanitarian access. And it ignores the International Court of Justice, which issued binding provisional orders that must be complied with. As appalling and apocalyptic as the situation was in December, it is even worse today. The Secretary General recognized this in a statement on 8 April. More than an entire month has passed without a drop of aid into Gaza. No food, no fuel, no medicine, no commercial supplies. As aid has dried up, the floodgates of horror have reopened. Gaza is a killing field, and civilians are in an endless death loop. The current path is a dead end, totally intolerable in the eyes of international law and history. And the risk of the occupied West Bank transforming into another Gaza makes it even worse. Mr. President, in these circumstances, there can be no doubt that Israel is violating its obligations under international humanitarian law, including its obligations under the Fourth Geneva Convention and customary international law, as reflected in Additional Protocol 1. In its written statement, Israel argues that its defense and security concerns justify its refusal to allow humanitarian assistance to the Palestinian civilian population, no matter how urgently this assistance is needed. This posture is as unlawful as it is inhumane. Under Article 59 of the Fourth Geneva Convention, as pointed out by the distinguished Undersecretary General for Legal Affairs earlier this morning, quote, "If the whole or part of the population of an occupied territory is inadequately supplied, the occupying power shall agree to relief schemes on behalf of the said population and shall facilitate them by all the means at its disposal." The ICRC commentary on Article 59 explains, "The obligation on the occupying power to accept such relief is unconditional. In all cases where occupied territory is inadequately supplied, the occupying power is bound to accept relief supplies destined for the population." The Convention not only lays down that the occupying power must agree to relief schemes on behalf of the population, but insists that it must facilitate them by all the means at its disposal. The occupation authorities must therefore cooperate wholeheartedly in the rapid and scrupulous execution of these schemes. Article 59 itself further provides, quote, "All contracting parties shall permit the free passage of these consignments and shall guarantee their protection." The ICRC commentary explains that these obligations apply to any state that is enforcing a blockade, and it specifies that the consignments, quote, "cannot under any circumstances, be declared war contraband or be seized as such by those enforcing the blockade. Mr. President, the question posed by the General Assembly calls for the Court to issue an opinion on Israel's legal obligations, and I quote, to ensure and facilitate the unhindered provision of urgently needed supplies essential to the supply of the Palestinian civilian population, as well as of basic services and humanitarian and development assistance. This question assumes that the relief consignments are humanitarian in nature. As such, international humanitarian law does not permit Israel to deprive the Palestinian civilian population of such assistance for any reason, including what it claims are its defense or security requirements. This is the conclusion reached by the ICRC itself. In relation to the current situation in Gaza, the ICRC has stated, the suspension of assistance now, including the cessation of power to the only water desalinization facility in Gaza, risks plunging Gaza further into an acute humanitarian emergency. Under international humanitarian law, Israel shall ensure that the basic needs of civilians under its control are met. The rapid and unimpeded passage of humanitarian assistance must also be allowed and facilitated. I now turn to Israel's legal obligations under the rules of international law applied by the Court in its 2024 advisory opinion. I refer specifically to the Court's determinations that Israel has no sovereignty and may not exercise sovereign powers in the occupied Palestinian territory, and that its presence there is unlawful, such that it must be terminated as rapidly as possible. I refer as well to the Court's determination that Israel has an obligation to facilitate and not to impede the right of the Palestinian people to self-determination, including the right to a sovereign and independent state in the occupied Palestinian territory, and that Israel, by its presence in this territory, its annexations and its settlements, among other actions, has been systematically violating that obligation. The Court further determined that third states and the United Nations are legally obligated not to accept the Israeli presence in the OPT as lawful or to contribute to its maintenance, and must work to bring it to an end, and that they have an erga omnes obligation to support the right of the Palestinian people to self-determination. These determinations by the Court have at least three inevitable consequences for the present proceedings. First, because its presence in the OPT is unlawful and it lacks sovereign rights or powers within the territory, Israel has no legal authority to impede humanitarian goods and services from entering or circulating within the Gaza Strip or any other part of Palestinian territory. The decision to accept and receive humanitarian assistance, and from whom, is an exercise of sovereignty, which, in the case of the Palestinian territory, belongs exclusively to the Palestinian people, who are represented by the State of Palestine. Accordingly, in addition to its obligations to ensure and facilitate the provision of humanitarian assistance to the Palestinian civilian population under international humanitarian law, Israel bears an obligation under general international law not to override the sovereign will of the Palestinian people, expressed through their legitimate governmental representative, to receive in their own territory such urgently needed assistance and services as they may authorize from the United Nations, third states, and other trusted organizations. Second, Israel's prevention of humanitarian assistance from entering Gaza also violates its obligation, in the Court's words, quote, not to impede the Palestinian people from exercising its right of self-determination. As the Court explained, the right of self-determination includes the right to territorial integrity, the right to be protected against acts aimed at dispersing the population and undermining its integrity as a people, and the right of the people freely to determine its political status and to pursue its economic, social, and cultural development. all of which the court found were violated by Israel's prolonged occupation of Palestinian territory. By preventing humanitarian assistance from entering Palestinian territory, Israel further violates each of these components of the right of self-determination. In particular, Israel's denial of food, water, and other essentials of life to the Palestinian civilian population inevitably impedes their economic, social, and cultural development. And it is intended, as Israeli officials themselves proclaim, to displace and disperse the Palestinian population, especially in Gaza, but increasingly in the West Bank as well, which undermines their integrity as a people. Mr. President, I see that the clock is approaching 11:30. I have somewhere between 5 and 8 more minutes of my speech remaining. If you allow me to continue, I would be happy to do so. If you prefer to take the coffee break, obviously that's fine with us. We're entirely in your hands.
I think we can have coffee after you finish your remarks.
Thank you very much, Mr. President. Israel's prevention of humanitarian assistance also violates the territorial integrity of Palestine, another essential component of self-determination. As shown on this map, in the southwest Gaza borders Egypt. The main border crossing is at Rafah, which is where most humanitarian assistance, before it was blocked by Israel, entered Gaza. Israel enforces its blockade on goods entering here from within Palestinian territory, thus violating its territorial integrity. The situation is similar in the east, where Israeli forces stationed in the West Bank, including East Jerusalem, prevent or restrict the entry of humanitarian assistance from Jordan via the King Hussein al-Karama bridge crossing, again, in violation of Palestinian territorial integrity. As the Secretary General observed, the humanitarian situation in the West Bank, including East Jerusalem, is also grave due to Israel's prevention or restriction of humanitarian assistance to the millions of Palestinians who live there. While Israel has not announced a formal cutoff of humanitarian assistance to the West Bank, as it has to Gaza, it has imposed major obstacles to the delivery of such assistance, including the arbitrary withdrawal or denial of operating permits for humanitarian organizations. According to the Commissioner General of UNRWA, while a number of international NGOs have already been silenced, there is now a larger concerted effort in Israel to undermine or restrict, through legislative measures, the operations of international organizations and NGOs. In occupied East Jerusalem, the agency is facing increased pressure from the municipality to vacate premises and end service provision. International staff have been effectively expelled from the occupied West Bank due to the lack of valid visas. The vast majority of the states and international organizations participating in these proceedings agree that Israel's shutdown of relief operations and denial of urgently needed humanitarian assistance to the Palestinian civilian population violate its duty not to impede the Palestinian people from exercising their right of self-determination. According to the Netherlands, for example, in a situation of extreme dependence on relief operations, the occupying power's unilateral decision to terminate its agreement and cooperation with a third party responsible for the bulk of the humanitarian assistance directly and severely affects a people as a whole, frustrating its economic, social, and cultural development. This has severe negative consequences on the ability of the people concerned to exercise its right of self-determination. The written statement of the Secretary General explains, quote, "The obligation of Israel to respect the right of self-determination of the Palestinian people has another important aspect: to respect the decision of the Palestinian people on the manner in which the dependence of the West Bank, including East Jerusalem and Gaza, on Israel for the provision of basic goods and services should be reduced. Therefore, in instances where the representative of the Palestinian people decided to receive basic goods and services from United Nations entities in order to fully enjoy its right of self-determination, Israel is bound to respect that decision. The third consequence of the 2024 advisory opinion is that Israel's prevention of humanitarian assistance from other states and the United Nations violates its duty not to prevent them from fulfilling what the court found to be their erga omnes obligations to support and facilitate the exercise of self-determination by the Palestinian people. Many states and international organizations emphasize this point. The African Union, for example, explains that as a member state of the international community, Israel must cooperate with third states to ensure the effective enjoyment by the Palestinian people of their right to self-determination. It must therefore grant all facilities at its disposal for the provisions by third states of the support necessary for the latter to be able to self-determine. Mr. President, I come now to the final part of my presentation, and the briefest, on Israel's legal obligations under parallel rules of international humanitarian law and international criminal law, particularly those which prohibit starvation of the civilian population as a method of warfare. This practice, which Israel, by admission of its senior government officials, deliberately employs against the Palestinian civilian population in Gaza, is unlawful under both Article 54.1 of Additional Protocol 1, which expressly prohibits it, and the Rome Statute, which provides in Article 8.2b that, quote, intentionally using starvation of civilians as a method of warfare by depriving them of objects indispensable to their survival, including willfully impeding relief supplies, is a war crime. In fact, starvation of civilians as a method of warfare has been recognized as a war crime, at least since the judgment of the Nuremberg Tribunal in 1946. 8 decades later, it is Israel that is deliberately starving more than 2 million Palestinian civilians in Gaza to achieve its purported war ends by cutting off all supplies of food, water, and other essentials of life. This has led the International Criminal Court to charge Prime Minister Netanyahu and former Defense Minister Gallant with the war crime of starvation. In allowing the prosecution to proceed, the pretrial chamber of the ICC explained, there are reasonable grounds to believe that both individuals intentionally and knowingly deprived the civilian population in Gaza of objects indispensable to their survival, including food, water, and medicine and medical supplies, as well as fuel and electricity, from at least 8 October 2023 to 20 May 24. The distinguished legal advisor of Mexico, Pablo Arocha Olabunaga, put it eloquently in an article he published last year. Its title is "Starvation is Starvation is Starvation." People in Gaza are being starved to death, and we are all witnessing it, if not complicit in it. But this human tragedy is a deliberate choice. It is the consequence of a political decision. It is both avoidable and reversible. All of us, as diplomats, international lawyers, humanitarians, but most importantly as individuals, have the moral obligation to raise our voices in outcry of this catastrophe and in efforts to stop it. Israeli authorities must ensure complete and unfettered access for humanitarian goods throughout Gaza. Human dignity simply cannot be held hostage to conflict. This must stop. The inhumanity of this Israeli policy is compounded by its unlawful objective to forever extinguish the right of the Palestinian people to self-determination, including a sovereign and independent state in their own territory, as part of the two-state solution that the international community demands. Mr. President, killing and maiming hundreds of thousands and starving and attempting to displace millions of Palestinians out of Palestine amounts to no less than destroying them as a group. In conclusion, the State of Palestine respectfully submits that Israel's unconscionable violations of its legal obligations under international humanitarian law and under the rules of international law set out in the Court's 2024 advisory opinion must be called out by the Court in its forthcoming advisory opinion, and they must be stopped. International law, we contend, requires this. Maintaining the credibility of the rules-based international order demands it. Thank you, Mr. President and members of the Court, for your kind courtesy and patient attention, and I respectfully request that after the coffee break, you call my esteemed colleague, Blina Negrali, to the podium. Thank you very much, and thank you very much for permitting me the extra time to complete my speech.
I thank Mr. Leichler. Before I give the floor to the next speaker, the Court will observe a coffee break of 50 minutes. The hearing is suspended. Please be seated. The sitting is resumed. I now invite Ms. Blin Nijari to address the court and continue the presentation of Palestine. You have the floor, Madam.
Mr. President, members of the court, it is an honour as ever to appear before you. It is also an immense privilege, though a weighty responsibility, to represent the state of Palestine in such extreme circumstances for the Palestinian people. I will address Israel's relevant obligations as a United Nations member, focusing on its obligations: 1, to cooperate with the United Nations; 2, to ensure the privileges, immunities and protection of UN staff and property; 3, to ensure the fundamental human rights of the Palestinian people; and 4, to abide by UN resolutions and this court's orders. Israel's violations of those obligations are egregious and ongoing. They are also in breach of Israel's obligation of good faith under the Charter, which is a fifth issue I will address and with which I will conclude. I address those legal issues in the context of the almost unimaginable and yet ever-worsening situation in the occupied Palestinian territory, particularly in Gaza. On the 27th of March of this year, the last international staff of the United Nations Relief and Work Agency left Gaza. Given Israel's recently passed anti-UNRWA legislation, no further UNRWA staff is likely to be permitted entry. 3 days earlier, on the 24th of March, the Secretary-General of the United Nations had announced his, I quote, difficult decision to reduce the organization's footprint in Gaza, even as humanitarian needs soar and the United Nations' concern over the protection of civilians intensifies, end quote. His decision, evocative of previous genocides in Rwanda and Bosnia, followed Israel's breach of the ceasefire agreement on the 18th of March 2025 and its resumption of its siege and large-scale assault on Gaza. As had been threatened by the Israeli Defense Minister, Israel Katz, I quote, "The gates of Gaza closed and the gates of hell reopened." Israel killed almost 500 people, including more than 180 children, in the deadliest 24 hours in Gaza since October 2023. One strike on a designated UN compound killed one international UN official and injured seriously 5 others. The Secretary-General's decision to reduce the United Nations footprint in Gaza followed days later. The United Nations itself cannot keep its staff in Gaza safe from Israel because nowhere and no one is safe. The past 18 months have been the deadliest ever in the history of the United Nations. Of over 418 aid workers killed in Gaza, 295 of them were UN staff. Most of them teachers, doctors, nurses, engineers, operational staff were Palestinian. Those Palestinian staff remain in Gaza. Their own footprint is also being reduced each day as they are injured and killed. As stated by Médecins Sans Frontières, Gaza has been turned into a mass grave of Palestinians and those coming to their assistance, end quote. In the words of the Secretary-General, it is a killing field. Since March 2025, Israel has no longer even maintained the pretense of designating so-called humanitarian zones. In the last month alone, it has bombed over 20 times the tents of the displaced in Al-Mawasi, the overcrowded sandy wasteland to which it repeatedly ordered Palestinians to flee, a ground invasion of which is now reportedly imminent. As stated by UNICEF, I quote, "Images of children burning while sheltering in makeshift tents should shake us all to our core." The warnings of United Nations officials could not be clearer, including by the head of office for OCHA in the occupied Palestinian territory, who himself remains in Gaza, I quote variously, "As humanitarian leaders, we are repeating unequivocally to the world, we are being deliberately blocked from saving lives in Gaza, and so civilians are dying. As humanitarians, we need to emphasize that we cannot accept that Palestinians are dehumanized to the point of being somehow unworthy of survival. What is happening here defies decency, it defies humanity, it defies the law." End quote. Before turning to what that law is in terms of Israel's obligations as a member of the United Nations, it's important to recall the reason for the organization's presence and vital role in Palestine. As recently acknowledged by the Israeli Finance Minister Smotrich, I quote, "For 75% of Gaza's population, it's not their homeland. Do you know what their homeland is? Haifa, Tiberias, Accra, Jaffa. This is a refugee population that has been in Gaza since 1948, end quote. Those refugees, their children and grandchildren, have indeed been in Gaza since 1948, and in East Jerusalem, and in the rest of the West Bank, and violently scattered to the four corners of the earth, since being forcibly expelled from their homes on the creation of the State of Israel. The mass displacement and dispossessions Palestinians refer to as al-Nakba, the catastrophe. They are the people, alongside those Palestinians previously long and deeply rooted in Gaza, whom Israel is bombing, starving, maiming and killing, and whom it has violently displaced over and over again for 18 long months. In the West Bank, including East Jerusalem also, Israel is subjecting to ongoing and intensifying attack that same refugee population, alongside other Palestinians, including those violently displaced previously since Israel's occupation began in 1967. Israel's ongoing mass displacements, its demolitions of homes, entire refugee camps and necessary infrastructure, and its ever-escalating killings of Palestinian men, women and children risk, in the words of the Secretary-General, transforming the West Bank into another Gaza. Having denied for 77 years the right of return of refugees and the peremptory right of Palestinians to self-determination, in violation of international law and UN resolutions, Israel is now seeking to destroy Palestinians as a group, including by inflicting on them conditions of life calculated to bring about their destruction, by seizing ever more Palestinian territory, and by turning Gaza into an uninhabitable wasteland incapable of sustaining human life. Having willfully destroyed the ability of the Palestinian people to sustain themselves independently, Israel is now intensifying its weaponization of the food and relief assistance on which it has long forced so many Palestinians to rely for their survival. It is also seeking to destroy UNRWA, the very agency mandated by the United Nations to provide them with life-sustaining aid and assistance, including to, I quote, "prevent conditions of starvation and distress among them," end quote, until a just and lasting resolution of their plight, in accordance with international law, including General Assembly Resolution 1943 of 1948. It is against that backdrop that I turn to Israel's breach of its duty to cooperate with the United Nations. Article 2.5 of the Charter stipulates that all members shall give the United Nations every assistance in any action it takes in accordance with the present Charter. This is a broad obligation of cooperation, binding members without restriction as to the nature of the action involved or the identity of the United Nations entity taking it, subject to the action being in accordance with the Charter. This is reflected in state practice, including written statements in these proceedings and numerous UN resolutions concerning Palestine. Israel now argues before this court that the Article 2.5 obligation should be interpreted as restricted to certain limited actions taken by the Security Council, where the United States repeatedly wields its veto to shield Israel from accountability. But Israel interpreted this obligation very differently when being considered for membership in the United Nations. At a meeting of the committee considering its application in 1949, Israel undertook unqualifiedly to, I quote, cooperate with the organs, plural, of the United Nations with all the means at our disposal in the fulfillment of the part of Resolution 194 concerning refugees, end quote. Israel has also interpreted the obligation broadly when commending other states for acting as, quote, loyal members of this organisation, end quote, in providing every assistance to the UN pursuant to Article 2.5. Israel cannot now credibly assert for itself a different interpretation of the Charter. The Court has itself confirmed the nature of the obligation in its Reparation for Injuries advisory opinion. It emphasised the importance of the duty, noting that, I quote, the effective working of the organisation, the accomplishment of its task, and the independence and effectiveness of the work of its agents require that these undertakings should be strictly observed. Accordingly, as the Secretary-General has underscored, it has been a long-standing position of the Secretariat, I quote, that Member States are required to provide every assistance to United Nations entities to ensure the effective implementation of their mandates. He reaffirmed this just 4 months ago in his letter to the Security Council and General Assembly, underscoring that as a member of the United Nations, Israel is required, quote, to give UNRWA every assistance, end quote, in any action taken in accordance with the Charter. Israel is intentionally and egregiously failing to do so. Secondly, and relatedly, Israel is egregiously breaching its obligations to respect the inviolability of UN premises and the immunity of UN premises, property and assets, pursuant to Charter Article 105 and Israel's obligations under the 1946 Convention on the Privileges and Immunities of the United Nations. Israel is similarly in egregious breach of its obligations to respect the privileges and immunities of UN officials, including salaried Palestinian staff, international staff, and experts on UN missions, including fact-finding missions. Those obligations are unqualified and apply both in times of peace and of armed conflict. They cannot be abrogated by a military occupier, particularly one that is unlawfully present in occupied territory. Given that those obligations bind Israel pursuant to the Charter and the 1946 Convention to which it is a party, they are entirely unaffected by Israel's announced withdrawal from its bilateral agreement with UNRWA. Israel's violations of those obligations in the West Bank, including East Jerusalem, include its forcible entry into UN schools, its seizure and often violent shuttering of UN premises, and its failure to protect them from attack by Israeli civilians. They also include Israel's obstruction or prohibition of the movement of Palestinian UN staff and of the access by international UN staff to the occupied Palestinian territory. In Gaza, Israel's violations of those obligations include its obstruction of UN aid, supplies, goods and equipment into and throughout the territory, and its attacks on UN food stores, distribution facilities and humanitarian convoys. Further violations include Israel's use of UN premises as military bases and its violent, lethal attacks on UN schools, shelters and healthcare facilities, which have been a feature of every large-scale military assault on Gaza since at least 2009. Since October 2023 alone, Israel has attacked more than 310 UN facilities in Gaza, many being struck repeatedly. Israel violates the immunities of UN officials, including by killing, injuring, and unlawfully detaining them, and subjecting them to violent interrogation and ill treatment, including severe beatings, waterboarding, deprivation of food and water, and threats of extreme harm to their families. Such violations against UN staff also constitute serious breaches of Israel's obligations under the 1973 Convention on the Prevention and Punishment of Crimes against Internationally Protected Persons. For 18 months and long previously, Israel has failed to prevent violent attacks on UN officials or to prosecute those responsible. The Israeli attacks on the 23rd of March 2025 on UN personnel and other aid workers in Rafah stands as a stark example. The slide on your screens shows the mangled wreckage of a UN vehicle, crushed by Israeli soldiers and hidden in the sand, buried alongside its murdered driver, a UN employee, and 14 medics and first responders, with their destroyed ambulances and fire truck. They were only recovered 6 days later, an initial joint UN mission to recover the bodies having been abandoned after, I quote, encountering hundreds of civilians fleeing under gunfire. The acting director of OCHA in Gaza described, I quote again, witnessing a woman shot in the back of the head. When a young man tried to retrieve her, he too was shot, end quote. As a video recording has exposed, the Israeli Army's Golani unit, responsible for the attacks on the 23rd of March, was briefed prior to its deployment to Rafah that, I quote, everyone you encounter is an enemy. If you spot a figure, open fire, eliminate, and move on. It was the recording of the Israeli attacks on the 23rd of March, found on the mobile phone of a slain Palestinian Red Crescent paramedic, that compelled Israel's retraction of its initial attempted justification of the killings. That recording of Refat Radwan's final words also reflects the sacrifice made by so many in Gaza who have given their lives for others. After reciting the Muslim prayers of the dying and knowing his mother's heart would be broken by his death, he called out, "Forgive me, Mother, forgive me. I chose this path to help people. Forgive me." As stated by the Director General of the International Committee of the Red Cross, quote, "The situation in Gaza will haunt us for decades because no one will be able to say we weren't aware. All the information is available. The images are there," end quote. They are being streamed from the phones of the living and the dead. All the information is available also of Israel's long-standing violations of the fundamental human rights of Palestinians, which is a third topic to which I now turn. Israel's actions, including those long predating October 2023, are an egregious violation of Articles 55 and 56 of Chapter 9 of the Charter. Through those articles, Israel, quote, "pledged to take joint and separate action in cooperation with the United Nations to promote higher standards of living and universal respect for and observance of human rights and fundamental freedoms for all," end quote. The obligations to which Chapter 9 gives rise are not optional. As the United States explained in its submissions in the Southwest Africa case, which concerned another situation of occupation of Namibia by apartheid South Africa, I quote, "In accordance with Chapter 9 of the Charter, states have an obligation to cooperate with the United Nations towards the realization of human rights and fundamental freedoms without discrimination for the people of Namibia," end quote. The same applies without discrimination to the people of Palestine. That is because through the Charter, the people of the United Nations, including Israel, have declared themselves, quote, "determined to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, and in the equal rights of nations, large and small." End quote. One of the foundational purposes of the United Nations is, I quote, "to achieve international cooperation in solving international problems of a humanitarian character and in promoting and encouraging respect for human rights and for fundamental freedoms for all, without distinction." End quote. International law protects and binds all peoples equally. There are no children of a lesser God. Yet for decades, Israel has denied and violated with impunity the fundamental human rights of the Palestinian people, in breach of its obligations under the UN Charter and international human rights law, while in parallel preventing attempts by the UN, other organisations and third states to ensure their fulfilment. It has violated the right of Palestinians to development, causing widespread poverty across the occupied Palestinian territory and forcing large numbers of people into dependence on international assistance. And then it has obstructed that international assistance or destroyed it once provided. It has violated the rights of Palestinians to food, to water, to health, to physical integrity, to education, to property, to shelter, and above all else, their right to life, including through the system of racial discrimination and apartheid it has imposed. The hundreds of thousands of Palestinian men, women and children whom it has imprisoned, many without charge or trial, have been particularly severely impacted. Israel's violations have been extensively documented by UN bodies and by Palestinian and international NGOs, and their breaches recorded by this court in 2 previous advisory opinions. However, even as against that standard, Israel's violations since October 2023 have been unprecedented. The International Criminal Court's arrest warrant for Israeli Prime Minister Netanyahu and former Defence Minister Gallant include the crime against humanity of persecution, defined as, I quote, "the intentional and severe deprivation of fundamental rights, contrary to international law, by reason of the identity of the group or collectivity." In addition to the war crime of starvation, dealt with in the previous presentation, warrants have also been issued for the crimes against humanity of murder and inhumane acts, involving killing and the infliction of great physical or mental suffering or serious injury, committed as part of a widespread or systematic attack against a civilian population. The ICC pretrial chamber considered, for example, that, I quote, "by intentionally limiting or preventing medical supplies and medicine from getting into Gaza, the 2 individuals are responsible for inflicting great suffering by means of inhumane acts on persons in need of treatment. Doctors were forced to operate on wounded persons and carry out amputations, including on children, without anaesthetics, causing these persons extreme pain and suffering." End quote. And almost inconceivably, the situation has deteriorated further since those warrants were issued. As of late 2024, the UN had already assessed that local water and food production in Gaza, crops, olive tree orchards, fishing, cattle and poultry farms had been all but destroyed, as had been essential services, including electricity, water and sewerage, alongside the destruction of bakeries, shops and trade. And now, no fuel, no medicine, no food, no water. Nothing has been permitted by Israel to enter Gaza for 57 days. 3 days ago, on Friday, the UN World Food Programme announced that it had now, I quote, "depleted all its food stocks in Gaza." Widespread malnutrition, rampant infectious diseases, alongside untreated conditions and the severe mental impact of Israel's assault on Gaza, together with its systematic destruction of 95% of Gaza's hospitals and maternity clinics, and its killing of so many of Gaza's medical experts will impact Palestinians for generations. This is not just about Gaza's present, but about its very future. And Gaza's future, its approximately 1 million children, are being impacted particularly severely. Children are literally freezing and starving to death. They include 79 children, including 8 newborn babies, who died during the particularly harsh cold weather of Christmas and New Year gone by. Gaza is now home to the largest cohort of child amputees in the world, the largest orphan crisis in modern history, and a whole generation in danger of suffering from stunting, causing irreparable physical and cognitive impairments. Over 15,600 children have been killed violently. Tens of thousands more of Gaza's children are injured or missing, and many of those surviving are so traumatized that they openly express the wish to die. They, like everyone in Gaza, are in desperate, urgent need of assistance, which Israel continues to block. As recently warned by the heads of 12 international aid agencies, I quote, "Survival itself is now slipping out of reach." Israel's acts are not just murderous and inhumane, they are genocidal, as the UN Commission of Inquiry and others have concluded, and as is the near consensus view across the human rights community. While the determination of Israel's international responsibility for genocide is the subject of other proceedings before this court, the risk to the right of Palestinians to be protected from acts of genocide is at issue in these proceedings. That is because the court is being asked to advise on Israel's obligations in relation to the provision of aid and other services to Gaza in the context of a binding determination by a competent organ of the United Nations, being the court itself, that there exists a real and imminent risk of irreparable prejudice to the right of Palestinians to be protected from acts of genocide, and that Israel must ensure humanitarian aid and basic services in that situation. Despite Israel's objections, there is nothing to prevent the court advising on the obligations flowing from that situation in these proceedings. On the contrary, given that what is an issue is at the very least a situation of a risk of a violation of a peremptory norm of an erga omnes nature, the court could itself risk, I quote, failing in the discharge of its judicial functions if it did not declare that there is an obligation, especially upon members of the United Nations, to bring that situation to an end quote, as the court underscored in the South West Africa case. In the context of what UNRWA's Commissioner General has called, I quote, one of the darkest times for our common humanity that we vowed would not happen again, end quote, the court might well consider it particularly important to remind all states again, as it did a year ago in Nicaragua versus Germany, of their international obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, as well as under other binding rules of international law. That brings me to the fourth and penultimate issue, Israel's violations of UN resolutions and the orders of this court. Applying the court's reasoning in South West Africa, there is no doubt that the 4 Security Council resolutions addressing the current situation in Gaza are binding decisions pursuant to Article 25 of the Charter, having regard to their subject matter, their imperative language, and the discussions leading to them. Those discussions include the Secretary-General's exceptional triggering in December 2023 of Article 99 of the Charter, the most powerful tool available to him, permitting him to bring to the Security Council, quote, any matter which, in his opinion, may threaten the maintenance of international peace and security, end quote. Israel's continuing failure to comply with those resolutions, with unanimous Resolution 2417, which condemns the unlawful denial of humanitarian access to civilian populations, and with dozens of other Security Council resolutions since its admission to the United Nations, constitute repeated violations of Charter Article 25, reflecting a fundamental rejection of the Security Council's authority. Israel has similarly defied numerous General Assembly resolutions, including those calling for an immediate humanitarian ceasefire, setting out the modalities for the implementation of this Court's 2024 advisory opinion, and, I quote, strongly deploring the continued and total disregard and breaches by the Government of Israel of its obligations under the Charter. End quote. Israel continues to defy Resolution 194 concerning the right of return of Palestinian refugees, with which it unequivocally undertook to comply on being admitted to UN membership, and Resolution ES 1024, demanding that Palestinians displaced during Israel's occupation be allowed to return home, as stipulated by this Court in its 2024 opinion. Israel has also repeatedly violated Charter Article 94(1) by failing to comply with this Court's binding orders in South Africa versus Israel. Israel's Prime Minister has rejected the Court's authority, asserting that, I quote, nobody will stop us, not The Hague, not the axis of evil, and not anybody else. Just 12 days ago, its Defence Minister declared, in defiance of this Court's orders, that, I quote, Israel's policy is clear, and no humanitarian aid is about to enter Gaza. In violation of the Court's order to maintain open land crossing points, in particular the Rafah crossing, previously described by the UN High Commissioner as, quote, the symbolic lifeline for 2.3 million people in Gaza, Israel has closed all crossings, and it has turned Rafah itself, once a refuge for almost 1.5 million displaced Palestinians, into a post-apocalyptic wasteland. The slide on your screens, reflective of the general tenor of Israeli media since at least October 2023, shows Rafah devastated, with the caption, "The annihilation of Rafah is complete," alongside an Israeli flag and a flexed bicep. Plans are reportedly underway for Israel to annex 75 square kilometres of Rafah, 1/5 of Gaza, to Israel's so-called buffer zone, permanently. This, together with Israel's continuing maritime blockade, cuts Gaza and its people off from direct aid and assistance and from the rest of the world. In further violation of the Court's orders, Israel continues to block UN-mandated investigatory bodies from Gaza, while destroying and burying evidence of its crimes. Despite the extraordinary efforts of Palestinian journalists, who are themselves repeatedly targeted and killed, so much remains undocumented. As stated by UNRWA's Commissioner General, I quote, I shudder to think of what will still be revealed about the horrors that have taken place in this narrow strip of land. Simultaneously, Israel obstructs external investigations. It does so while its officials denounce the UN Commission of Inquiry and the UN Human Rights Council itself as, quote, a propaganda mouthpiece for terrorist organizations and anti-Semitic Israel haters engaged in blood libels, and calls for the Council to be, quote, removed from this earth. And so to my final submission concerning the principle of good faith, one of the United Nations bedrock principles set out in Article 2.2 of the Charter. It provides, all members, in order to ensure to all of them the rights and benefits resulting from membership, shall fulfil in good faith the obligations assumed by them in accordance with the present Charter. The obligation, reaffirmed in the Declaration on Friendly Relations, was described by the Court in the nuclear test case as, quote, one of the basic principles governing the creation and performance of legal obligations, whatever their source, end quote. It reflects not only the maxim of pacta sunt servanda, but also that of qui habet commode, fere debet honora. Whomever receives the advantages must also bear the responsibilities. Israel is failing to fulfill its charter responsibilities in good faith. Its violations of the fundamental rights of the Palestinian people, its attacks on the United Nations and on UN officials' property and premises, its deliberate obstruction of the organisation's work, and its attempt to destroy an entire UN subsidiary organ are unprecedented in the history of the organisation. They evidence a fundamental repudiation by Israel of its charter obligations, owed both to the organisation and to all UN members, and of the international rule of law. They are antithetical to the actions of a peace-loving state. Israel's very submissions to this court violate its obligations to cooperate with the UN in good faith, advancing allegations for which Israel has persistently failed to provide credible evidence. This is notwithstanding the Secretary-General's call on Israel, quote, to refrain from such misrepresentations, end quote, given how very damaging they are to the United Nations. But for Israeli officials, damage to the United Nations appears to be the point. Their attacks are not limited to UNRWA or indeed the UN Human Rights Council. Israel has declared the Secretary-General of the United Nations himself persona non grata in Israel, accusing him of being, quote, an official Hamas spokesperson engaged in anti-Semitic and anti-Israel conduct. Israeli officials demand his resignation, labelling his triggering of Charter Article 99 and his calls for a ceasefire in Gaza, quote, a danger to world peace. Senior Israeli officials level similar accusations at the United Nations itself as an organisation, denouncing it as, quote, a swamp of anti-Semitic bile, an accomplice to terrorists, and a stain on humanity. Israeli officials have even sought to discredit this court, calling it, quote, an anti-Semitic court comprising judges from Muslim dictatorships, which has been manipulated and weaponized in the persecution of the Jewish people. As stated by UNRWA's Commissioner General, I quote, the international order is crumbling in a repetition of the horrors that led to the establishment of the United Nations and in violation of commitments to prevent their occurrence. The attacks on UNRWA are an integral part of this disintegration, end quote. Not stopping at UNRWA, the Israeli ambassador to the United Nations itself has demanded that the entire UN and, quote, its corrupt courts, the ICC and the ICJ, must be defunded, end quote. In addition to seeking to destroy the protective application of international law to the Palestinian people, Israel appears set on destroying the very international framework created to ensure compliance with international law and accountability for its breach, with profound consequences that reverberate far beyond Palestine and Palestinians. If these venerable institutions are to survive, and if, in the words of the UN Relief Chief, quote, the basic principles of law still count, the international community must act while it can to uphold them, end quote. Mr. President, members of the Court, the international community is so acting in seeking the Court's advice on these matters, having regard to the Court's prior vital, unwavering reaffirmation of international law in its 2024 advisory opinion. Mindful of the former Secretary-General's description of the United Nations as, quote, the hope and home of all humankind, with the Charter at its compass, end quote, the State of Palestine respectfully calls on this Court to provide this further advisory opinion urgently to reset that compass in the continuing desperate hope that international law might finally prevail. Monsieur le Président, Mesdames et Messieurs les juges.
Mr. President, members of the Court, I thank you for your kind attention, and I ask you to now call Professor Imseis.
I thank Ms. Nijali. I now give the floor to Mr. Adri Imseis. You have the floor, sir.
Members of the Court, it is an honor to appear before you today on behalf of the State of Palestine and the Palestinian people. I have been given the task of addressing the issue of UNRWA, and to that end, I should like to make 3 points. First, for context, I will discuss the unique historical and operational importance of UNRWA. Second, I will demonstrate both why and how Israel has set upon to destroy the agency. And third, I will discuss Israel's legal obligations towards UNRWA, which this court has urgently requested to affirm by the vast majority of states and international organizations in these proceedings. First, the context. UNRWA's mandate is an essential element of what the court has twice recognized as the permanent responsibility of the United Nations for the question of Palestine. This responsibility originates in the unsuccessful attempt by the General Assembly to partition Palestine, and without the consent of the Palestinian people, in 1947, and the ensuing 1948 Nakba, during which between 750,000 and 900,000 Palestinians were forcibly exiled from that part of Palestine that became Israel. In Resolution 302 of 8 December 1949, the General Assembly recognized that continued assistance for the relief of the Palestine refugees is necessary to prevent conditions of starvation and distress among them, and to further conditions of peace and stability. UNRWA was created to provide direct relief and works programs to the refugees until their plight was resolved in accordance with international law. The Assembly therefore determined that UNRWA's mandate was to be discharged without prejudice to the right of the Palestine refugees to return to restitution and to compensation in accordance with Resolution 194 of 11 December 1948. But these rights, Mr. President, have never been allowed to be realized. Indeed, with the Israeli occupation of the rest of Palestine in 1967, another 250,000 to 300,000 Palestinians were forcibly exiled and became dependent on UNRWA. And the conditions of starvation and distress have not only continued over the years to varying degrees, but as the court knows only too well, since October 2023, they have gathered a pace never before seen. In essence, it is because of Israel's prolonged violation of the inalienable rights of the Palestinian people to return to self-determination, indeed to freedom, that the need for UNRWA is as pressing today, if not more so, than it was in 1949. The General Assembly agrees with this assessment. It has continuously renewed UNRWA's mandate with overwhelming support, insisting that until the Palestine refugees realize their rights under international law, UNRWA must remain in place. Operationally, UNRWA provides education, health, relief and social services, and during emergencies, humanitarian aid. And generations of Palestinians have been sustained by these quasi-governmental services in Jordan, Lebanon, Syria, and the occupied Palestinian territory. Uniquely, UNRWA's services are directly delivered by thousands of personnel, the vast majority of whom are themselves registered Palestine refugees with the agency. In the occupied Palestinian territory, the number of these staff literally dwarf that of other UN personnel by orders of magnitude, possessing decades of experience, expertise, and all-important community trust. And for these reasons, the necessity of UNRWA is indisputable. The sheer scope of continued Israeli violations of Israeli rights, or rather of Palestinian rights, forgive me, including the right to the unhindered provision of urgently needed humanitarian supplies essential for their survival, as well as the right for basic services, humanitarian and developmental assistance in support of their right to self-determination, renders UNRWA absolutely vital. As recognized by the General Assembly in the referral resolution, no organization can replace or substitute the agency's capacity or mandate. Mr. President, the Secretary General agrees. He states that UNRWA is indispensable in delivering essential services to Palestinians, and that UNRWA is the backbone of the United Nations humanitarian relief operations in Gaza. This conclusion is shared by other UN and humanitarian agencies operating in Palestine who rely on UNRWA's unmatched operational infrastructure, partnership, and support. It is also shared by nearly all participants in these proceedings, including China, which has referred to UNRWA as indispensable and irreplaceable, both Mexico and Luxembourg, which have each called UNRWA unique and irreplaceable, and Algeria, which has labeled UNRWA the cornerstone of the humanitarian assistance in occupied Palestinian territory. In his written statement, the Secretary General provided incontrovertible empirical evidence in support of this position. I quote, "Since October 2023, UNRWA has supported nearly 2.3 million affected individuals in Gaza with food, health care, and shelter. It has distributed food aid to around 1.9 million people and provided more than 60% of primary health care services in Gaza. Furthermore, UNRWA has sheltered hundreds of thousands of internally displaced persons in more than 100 schools and continues to deliver psychosocial support and primary health consultations. Between 7 October 2023 and 19 January 2025, UNRWA facilitated over 7.3 million medical consultations across Gaza. In the occupied Palestinian territory as a whole, the Secretary General reports further that UNRWA operates almost 400 schools, providing education to more than 350,000 students, and over 65 primary health clinics and 1 hospital, facilitating over 5 million health consultations annually. It does this, all of this, with 17,000 personnel. In sum, the evidentiary record shows that UNRWA is not just any humanitarian aid organization. It is organically linked to the unique role played by the United Nations in the question of Palestine since 1947, in particular the plight of the Palestine refugees. It is critical to the economic, social, and cultural development of the Palestinian people, and hence their ability to exercise their right of self-determination. And since October 2023, it has been essential to their very survival as a group, especially in Gaza. Mr. President, members of the Court, I now turn to the question of why Israel wants to prevent UNRWA from exercising its mandate. Based on the evidentiary record, Israel's reasons appear to be twofold, one short-term, the other long-term, both indeed inconsistent with its obligations under international law. At the very least, in the short term, Israel is pursuing the erasure of the Palestinian people in Gaza and ultimately the rest of the occupied Palestinian territory, including through forcible transfer. In Gaza, where almost 80% of the population are already registered refugees connected to the events of 1948, almost the whole of the population, some 1.9 million people, has been forcibly transferred multiple times through Israel's indiscriminate bombardment and starvation campaign. Nor has Israel made a secret of its actions in this regard. Quite the contrary, following multiple calls by government ministers over the course of 2024 to depopulate Gaza and resettle it with Israelis, on 28 January 2025, Israeli military Chief of Staff Herzi Halevi announced a decision to prevent displaced Palestinians from returning. In his words, and I quote, "Gazans will be able to exit the Rafah crossing for Egypt, but only in a one-way direction, and they will not be able to return to Gaza." On 5 February 2025, the Israeli Minister of Defense, Israel Katz, ordered the preparation arrangements for what he euphemistically called the voluntary departure of Palestinians. On 19 March 2025, Minister Katz's previously noted final warning to the citizens of Gaza included the following exhortation, and I quote, "Return the hostages and expel Hamas, and other options will be presented to you, including relocation to other places in the world for those who wish. The alternative is utter destruction and devastation," end quote. In the West Bank, in the past 4 months alone, over 40,000 Palestine refugees have been yet again forcibly transferred through the destruction of 4 refugee camps by Israel, aided by armed gangs of Israeli settlers who operate alongside Israeli occupation forces. Palestinian West Bankers are literally being forcibly displaced every day. Mr. President, the writing is on the wall. With these brazen suggestions that the departure of Palestinians would be voluntary, Israel is not merely insulting the world's intelligence, it's just simply assuming the world has none. After killing or injuring close to 170,000 Palestinians, after turning Gaza into a moonscape of dust and rubble, with over 70,000 tons of bombs, amounting to more than what was dropped on Dresden, Hamburg, and London combined during World War II, after destroying or damaging over 92% of civilian housing, 88% of schools, 84% of health facilities, 95% of water and sanitation systems, and 92% of roads, use of this Orwellian language by Minister Katz must be seen for what it is: an open call to expel as many surviving Palestinians as possible. And as promised by Minister Katz, he's already announced the establishment of an Israeli directorate to oversee the whole thing. Mr. President, my point here is this: elimination of UNRWA is essential to the success of Israel's dreaded plans. Given the scope of UNRWA's capabilities in providing emergency relief, stability, and resilience to the Palestinian population in ways that no other organization can operationally do, it is painfully obvious why Israel insists on eliminating the agency. Quite simply, UNRWA is the last hope that the Palestinian people, particularly in the Gaza Strip, have of surviving Israel's genocide against them. More broadly, Israel's long-term purpose behind destroying UNRWA rests in its complete denial of the existence of the Palestinian people, and in particular the status, rights, and claims of millions of Palestine refugees to return, to restitution, and to compensation. But you needn't take my word for it. The Prime Minister of Israel has openly admitted as much on multiple occasions, including, it must be stressed, years before 7 October 2023. For instance, on 11 June 2017, Prime Minister Netanyahu proclaimed, and I quote, "I regret that UNRWA, to a large degree by its very existence, perpetuates and does not solve the Palestinian refugee problem. Therefore, the time has come to disband UNRWA," end quote. Similarly, on 7 January 2018, Mr. Netanyahu said, quote, "UNRWA is an organization that perpetuates the Palestinian refugee problem. It also perpetuates the narrative of the right of return, as it were, in order to eliminate the state of Israel. Therefore, UNRWA needs to pass from the world," end quote. Of course, as members of the court will no doubt be aware, Palestine refugee rights are not legally contingent on UNRWA's existence. Nevertheless, according to Israel's strained logic, it is UNRWA, not Israel itself, that is to blame for the continued exile and deprivations of the Palestine refugees. To avoid having to answer for this, therefore, Israel simply wants to do away with the agency. Mr. President, members of the court, I now turn to the issue of how Israel has pursued its objective of destroying UNRWA. In this respect, Israel's approach has been threefold. First, Israel has systematically attacked UNRWA personnel and property. Only since October 2023, almost 300 UNRWA personnel have been killed by Israel in the Gaza Strip alone, with hundreds more wounded, many for life. Numerous others have been abducted from UNRWA premises and tortured, including to coerce confessions implicating themselves or other agency officials in the events of 7 October. In Gaza, Israel has damaged or destroyed over 310 UNRWA premises since October 2023. These include schools and healthcare facilities, many converted into shelters in which thousands of Palestinian civilians have been killed or injured. In the West Bank, Israel has repeatedly violated its obligations to protect UNRWA premises and property, including UNRWA headquarters in East Jerusalem. which has been subjected to arson attacks by Israeli settlers and is now earmarked for Israeli settlement, having been shuttered by Israel in January. Scores of other UNRWA facilities have been attacked, including forcible entry and takeover. For example, on 18 February 2025, Israeli troops forcibly commandeered the UNRWA Kalandia Training Center, home to 350 students. Likewise, only on April 8th, Israel ordered the closure of 6 UNRWA schools in East Jerusalem, affecting 800 children. Mr. President, the second element of Israel's plan to destroy UNRWA is its campaign to undermine the agency's vital sources of funding. On 26 January 2024, the same day this court issued its first provisional measures order in the South Africa matter, after determining that famine was around the corner in Gaza, Israel urged UNRWA's donors to defund the agency, alleging involvement of UNRWA staff in the attack of 7 October. The resulting funding pause by 18 states added massive pressure on agency operations at a time when millions of beleaguered Palestinians needed UNRWA the most. Israel has repeatedly claimed, and without substantiation, including in its written statement in these proceedings, that upwards of approximately 12% of UNRWA employees in Gaza are members of what it calls terrorist groups. But as the court is well aware, unsupported allegations do not a fact make, no matter how loudly shouted or oft repeated. The fact is that UNRWA has always responded to Israel's allegations in substance, in good faith, and in a timely manner. As the Secretary General reported on 8 January 2025, UNRWA has responded to every allegation that has been raised by the government of Israel against personnel of UNRWA regarding possible political activity that may be against the interest of the United Nations or connections to acts of terror, based on its policy of zero tolerance for activities of this nature. This is demonstrated by the actions taken by UNRWA following allegations that its personnel may have been involved in the attacks of 7 October 2023. Upon receiving the allegations, immediate administrative steps were taken. I immediately referred the allegations to the Office of Internal Oversight Services for investigation under the organization's regulatory framework. Such actions were consistent with the history of UNRWA engagement with the government of Israel, whereby it has been responsive to allegations raised by the government of wrongdoing by UNRWA personnel, end quote. This, of course, is in addition to the finding of the independent review group on UNRWA commissioned by the Secretary General in February 2024, that UNRWA possesses a more developed approach to neutrality than other similar UN or NGO entities. Following UNRWA's commitment to implement the recommendations of the review group, nearly all states that paused their funding have since resumed it. Mr. President, the third element of Israel's campaign to destroy UNRWA has been the passage of 2 anti-UNRWA laws in October 2024. They have been discussed earlier, so I'll quickly skirt over those. This legislation has had grave implications for UNRWA operations across the occupied Palestinian territory, including in East Jerusalem, over which Israel has unlawfully asserted its sovereignty, as was affirmed just this past summer. Israel's anti-UNRWA legislation, together with its broader attacks against UNRWA, have been roundly rejected by the Security Council, which has spoken with one resolute voice. And I quote, "The members of the Security Council strongly warned against any attempts to dismantle or diminish UNRWA's operations and mandate, recognizing that any interruption or suspension of its work would have severe humanitarian consequences for millions of Palestinian refugees who depend on the agency's services, and also implications for the region." Forgive me, I see the, right, there we are. The members of the Security Council expressed their grave concern over legislation adopted by the Israeli Knesset, and in this regard, they urged the Israeli government to abide by its international legal obligations, respect the privileges and immunities of UNRWA, and live up to its responsibility to allow and facilitate full, rapid, and safe and unhindered humanitarian assistance in all of its forms into and throughout the entire Gaza Strip including the provision of sorely needed basic services to the civilian population. I will now turn to my third and final point, namely, what are Israel's legal obligations in respect of UNRWA? Now, given what you've heard from my colleagues this morning, I can be brief in this respect. First, as part of its obligation to respect the right of the Palestinian people to self-determination, Israel is required to facilitate and expand, not ban, disrupt, or attack UNRWA operations in the occupied Palestinian territory. In the referral resolution, the General Assembly specifically called upon Israel to uphold and comply with its obligations, not to impede the Palestinian people from exercising their right to self-determination, including by rescinding any measures that obstruct the provision of basic services and humanitarian and development assistance to the Palestinian people. This plainly includes the services delivered by UNRWA, which is present in the occupied Palestinian territory, it is important to recall, not only at the direction of the General Assembly, but also at the invitation of the State of Palestine and the Palestinian people. Second, all of the international humanitarian law obligations of Israel covered by Mr. Reichler apply with equal force in respect of UNRWA operations in the occupied Palestinian territory. In particular, Article 59 of the Fourth Geneva Convention requires that the occupying power shall agree and facilitate relief schemes if the whole or part of the population of the occupied territory is inadequately supplied. Now, Israel's flagrant breach of this unconditional rule is aggravated by the fact that it is Israel itself who is responsible for the need for relief schemes in the first place. This rule must also be read in conjunction with the binding provisional measures order of the Court of 28 March last year, requiring Israel to, quote, ensure without delay, in full cooperation with the United Nations, the unhindered provision at scale of urgently needed basic services and humanitarian assistance throughout Gaza. Mr. President, I see we're coming up on the break. All I need is another 2 minutes, maybe 3, and I beg your thank you very much.
You can go ahead.
Given UNRWA's unmatched ability to provide relief schemes and to do so at scale to the Palestinian population, there can be no doubt that Israel is obligated to facilitate and expand the agency's vital work, rather than attack and sabotage it. Third, the obligation of Israel as a member of the United Nations, covered by Ms. Nagrali, all apply to its relations with UNRWA. Israel's abrogation of its bilateral agreement with UNRWA does not release it from these broader commitments. Israel remains under an obligation to cooperate in good faith with UNRWA, which requires it to give the agency every assistance in any action taken in accordance with the Charter, and as has been affirmed by the Secretary General. Israel must also ensure and respect the agency's privileges and immunities, which it enjoys as a subsidiary organ of the United Nations, including in respect of its premises, property, assets, and officials. And of course, Israel is also required to ensure the safety of UNRWA personnel. Mr. President, members of the Court, as I close my presentation, I should like to recall the sobering plea made by the Commissioner General of UNRWA in a letter to the President of the General Assembly dated 28 October 2024. He stated, and I quote, "Today I must inform you that the agency is under such physical, political, and operational attack unprecedented in United Nations history, that implementation of its mandate may become impossible without the decisive intervention by the General Assembly. The consequences for Palestinians, for Israel, and for the region will be grave," end quote. Mr. President, the General Assembly has answered the Commissioner General's appeal by placing the question of UNRWA's very future, and with it the rights, status, and existence of the Palestinian people, including millions of Palestine refugees, before you. No less than that is what is at stake in these proceedings. Mr. President, members of the Court, this concludes my presentation, and I should like to thank you for your time and careful attention. This also concludes our presentation for this morning. Professor Pillay will continue when we reconvene this afternoon. Thank you.
I thank Mr. Msays. This concludes this morning's sitting. The oral proceedings will resume this afternoon at 3 p.m., which Palestine will complete its presentation, when the Palestine will complete its presentation, and will be followed by Egypt and Malaysia. The sitting is closed.
where you do not need to ask what is the nationality or religion or race of a child killed to know if you should be outraged or find excuses, where parents do not live in fear, where children do not discover death before they had a chance to experience life. That alternative vision is why humanity enacted rules and established courts to bend the arc of the moral universe toward justice. To bend the arc of the moral universe toward justice. Justice, not vengeance. Justice, not double standards. Justice, not cruelty. We are here because the General Assembly needs your guidance to advance justice. We are here as millions of Palestinians, in particular, 2 million plus in Gaza, half of them children, pay the ultimate price for our collective inability to end the injustice. Help us deliver justice. Help us to move in that direction and to have justice for the Palestinian people. I thank you very much, Mr. President.
I thank the representatives of Palestine for their presentation. Before I invite the next delegation to take the floor, the court will observe a coffee break of 50 minutes. The hearing is suspended. Please be seated. The sitting is resumed. I now invite the next participating delegation, Egypt, to address the court. And I call His Excellency Mr. Hatem Kamal Abdelkader to the podium. You have the floor, sir.
Thank you, Mr. President. It is my honor and privilege to represent the Arab Republic of Egypt in these advisory proceedings, taking place through an urgent request of the General Assembly. Less than 1 year since the court issued its advisory opinion on the legality of the policies and practices of Israel in occupied Palestine. Mr. President, since 2nd of March, Israel has deliberately and arbitrarily closed the crossings into Gaza, preventing the entry of food, safe drinking water, fuel, medical, and other essential supplies. This brutal siege imposed on civilians is the most recent chapter in Israel's systematic weaponization of humanitarian assistance. It comes amidst Israel's resumption of its vicious assault on Gaza that has killed 52,000 innocent civilians since October 2023, the majority of whom are women and children. Israel continues to deliberately target civilians and the infrastructure essential to the survival of the Palestinian population, and has scaled up attacks against medical and humanitarian workers. This blatant disregard for international law has left Gaza in the throes of a humanitarian catastrophe. There is no doubt that these practices are part of a widespread, systematic, and comprehensive state policy to depopulate the occupied Palestinian territory and effect its de facto annexation. This policy is evident not only in a series of public statements by senior Israeli officials and in Knesset enactment, but equally in Israel's sustained efforts to undermine and defund UNRWA with the aim of obstructing the Palestinian people's inalienable right to return, a distinct pillar of the right to self-determination. Simultaneously, Israel repeated forced evictions and relocations under the guise of so-called evacuation orders, have forcibly transferred Palestinians to areas no more secure than the places they left, with no access to life-saving supplies and services. Israel is intentionally creating conditions intended to make Gaza uninhabitable. Mr. President, further embodiments of Israel's strategy include the creation of an agency charged with encouraging and managing the deportation of Palestinians from Gaza. Taken together, these practices demonstrate a clear and unified state policy aimed at de-Palestinizing the OPT in grave violation of international law. Mr. President, although this court has established that the continued presence of Israel in the occupied Palestinian territory is illegal until such time as the occupation ends, Israel remains bound by its obligations under international humanitarian law and international human rights law. Egypt's participation in the current proceedings stems from our strong belief that the role of this august court and international law and its institutions in protecting the Palestinian people until such time as they can achieve their sovereign independent state based on the June 1967 lines within the framework of the two-state solution. Egypt's statement will focus on three main points, namely, Israel's obligations as a member of the United Nations under the United Nations Charter and the General Convention on Privileges and Immunities in relation to the presence and activities of UNRWA, other United Nations entities and third states. 2, Israel's obligation as an occupying power to ensure and facilitate the unhindered provisions of urgently needed supplies, humanitarian and development assistance under international humanitarian law and international human rights law. And third, finally, the legal consequences and a summary of Egypt's submissions. First, with respect to the questions of Israel's obligations in relation to the presence and activities of the United Nations, including its agencies and bodies, other international organizations, and third states in and in relation to the occupied Palestinian territory, including East Jerusalem, distinguished members of the court, there's no doubting the United Nations' role, together with its agencies and other humanitarian organizations, in alleviating the humanitarian suffering of the Palestinian people, a situation entirely of Israel's own creation. Of all the international organizations operating in the occupied Palestinian territory, the role of UNRWA, established under United Nations General Assembly Resolution 302 of 8th of December 1948, is particularly indispensable. Not only does UNRWA provide life-saving humanitarian assistance and relief, it has filled the gap resulting from Israel's denial of the Palestinian people's sovereignty over their land and its constant suppression of Palestinian authorities' ability to fully assume its governmental functions throughout the OPT. This mandate includes providing basic needs and public services, including health care, education, social assistance, livelihood, and infrastructure. Mr. President, the General Assembly has underscored that no organization can replace or substitute the agency's capacity and mandate to serve Palestinian refugees and civilians in urgent need of life-saving humanitarian assistance. Since its inception, UNRWA was conceived to provide humanitarian and developmental assistance until Palestinian refugees were able to exercise their inalienable right of return. This is reflected in numerous General Assembly resolutions, which note with regret that the right of return has not been effected, and affirm the necessity for continuation of UNRWA's work and unimpeded operations pending a just resolution of the Palestinian refugee question. Distinguished members of the court, in blatant disregard for international law, on 28th of October 2024, Israel's Knesset enacted 2 laws related to UNRWA. The first of these, the law to cease UNRWA operations, unilaterally terminated the exchange of letters concluded between Israel and UNRWA on the 14th of June 1967, and prohibited Israeli government authorities from establishing any contact with UNRWA. This effectively prevents UNRWA from continuing its essential work in the OPT, including East Jerusalem, as mandated by the General Assembly. The law also allows for criminal proceedings against UNRWA employees in violation of their immunities. Israel simultaneously enacted the law to seize UNRWA operations in the territory of the State of Israel, which prevents UNRWA operations through any representative office services, or activities directly or indirectly within the sovereign territory of the State of Israel. Under this law, Israel requested UNRWA to cease its operations in Jerusalem and evacuate all premises in which it operates in the city, including the premises in East Jerusalem. These grave violations are only the latest in a series of measures intended to impede UNRWA's operations, including attacks against UNRWA personnel and premises, forced entry and incursions into UNRWA facilities, restrictions on the access and movement of UNRWA personnel, and preventing UNRWA from transporting humanitarian relief into the OPT. These practices are part of a broader policy aimed at undermining and disbanding UNRWA altogether, obstructing its humanitarian mandate, the right of return, and driving Palestinian displacement and dispossession in violation of the principle of self-determination. Mr. President, Israel's measure against UNRWA and other United Nations organizations violate a number of distinct legal regimes that exist and operate simultaneously and concurrently. These include: 1. The jus ad bellum and the preemptory prohibition of the acquisition of territory through force. The Palestinian people inalienable right to self-determination. 3. Israel's obligation arising under the Charter of the United Nations. 4. Israel's obligation under the rules of international law relating to the privileges and immunities of UNRWA as a subsidiary organ of the United Nations, which principally arise from the 1946 Convention on Privileges and Immunities of the United Nations. 5. The principles of international humanitarian law and international human rights law. First, with respect to the jus ad bellum, Israel's enactment of these laws and any measure taken pursuant to them in the OPT amounts to a purported exercise of Israel's sovereign power in occupying East Jerusalem, in violation of international law, including the Palestinian people's right to self-determination. Consequently, Israel is under an obligation to repeal these laws, which are null and void, and not to engage in any legislative or other measures to advance their implementation. Second, with respect to the Palestinian people's inalienable right to self-determination, the Court has already stated that in cases of foreign occupation, such as the present case, the right to self-determination constitutes a preemptory norm of international law. The Palestinian people's right to self-determination thus cannot be achieved until Israel ends its unlawful presence in the occupied Palestinian territory. Preserving and effecting the right of return is essential to enabling the Palestinian people to exercise the right to self-determination. The right of return is embodied in paragraph 11 of General Assembly Resolution 194, which states, and I quote, resolves that the refugees wishing to return to their homes and live at peace with their neighbors should be permitted to do so at the earliest practicable date, and that compensation should be paid for the property of those choosing not to return, and for loss of or damage to property which under principles of international law or in equity should be made good by the government or authorities responsible. The United Nations General Assembly has stated that the right to return is indispensable for a just settlement of the refugee problem and the exercise by the people of Palestine of its right to self-determination. UNRWA's mandate is intrinsically linked to the right of return. The international community has repeatedly recognized that as long as the right of return is not achieved, UNRWA would continue to discharge its mandate. By implication, UNRWA's continued existence and the General Assembly regular renewal of its mandate without prejudice to paragraph 11 of Resolution 194 became synonymous with preserving the right of return for the Palestinian refugees. There can be no substitute to UNRWA until such time as the right of return is achieved in accordance with Resolution 194. And the sovereign Palestinian state, with function and effective state institutions, is capable of assuming UNRWA's functions. The Palestinian Authority has entered into undertakings that express its consent to UNRWA's presence and activities in the OPT and demonstrate its commitment to the privileges and immunities enjoyed by UNRWA as a subsidiary organ of the United Nations. Accordingly, Egypt submits that Israel is under an obligation not to prevent, impede, or otherwise restrict the presence of activities of UNRWA in the OPT, including East Jerusalem, or to prevent it from executing its mandate. Any such measures constitute a violation of the right of return of Palestinian refugees and the right of the Palestinian people to self-determination, and is integral to Israel's attempts to expel, displace, transfer, or deport the Palestinian people from the OPT in stark violation of international law. Third, with respect to Israel's obligations arising under the Charter of the United Nations, Mr. President, there is no other state in the international community that has disregarded the United Nations Charter with such impunity. As a member of the United Nations, Israel is bound to respect Article 2, Paragraph 5 of the Charter, which establishes a general obligation to collaborate with the organization in the fulfillment of its actions. As a subsidiary organ of the United Nations, the activities of UNRWA in the occupied Palestinian territory are an action taken by the United Nations in accordance with the present Charter. Within the meaning of Article 2, Paragraph 5, there is nothing in the letter or spirit of the Charter that suggests that the term action is limited only to enforcement actions under Chapter 7. This august court already established that a state's membership in an international organization entails certain mutual obligations of cooperation and good faith. The court further stressed the importance, and I quote, of the duty to render to the organization every assistance which is accepted by the member in Article 2, Paragraph 5 of the Charter. Article 105 of the Charter further provides for the member states respects for privileges and immunities necessary for the fulfillment of its purposes, while Articles 100 and 104 protect what the court has called the independent action of the organization itself. Together, these articles embody Israel's obligation to actively facilitate and not to prevent, impede, or otherwise restrict the presence and activities of UNRWA and other United Nations agencies and bodies operating in the OPT, including East Jerusalem. Fourth, with respect to Israel's obligations under principles of international law relating to the privileges and immunities of UNRWA, Egypt submits that Israel is under an obligation to respect the privileges and immunities of UNRWA and other United Nations agencies and bodies which arise from the United Nations Charter and the 1946 Convention on Privileges and Immunities of the United Nations. The General Assembly has confirmed Israel's obligation as a party to the General Convention to accord the privileges and immunities set out in the Convention to the United Nations and its subsidiary organs. General Assembly Resolution ES-10/25 of 11 December 2024 demanded that Israel respect the mandate of the agency and its privileges and immunities and act forthwith to enable its operations to protect without impediment or restriction in the Gaza Strip and the West Bank, including East Jerusalem. The General Convention states in Section 34 that when a state accedes to the Convention, it will be in a position under its own law to give effect to its terms. Any Israeli measures relating to UNRWA must therefore be consistent with Israel's obligation under the Convention, including immunity of UNRWA and other United Nations entities and their officials from every form of legal process, including legislative and enforcement jurisdiction. The absolute and mandatory inviolability of UNRWA premises, property and assets, including health centers, warehouses and headquarters, providing access to and free movement of UNRWA. Mr. President, Israel has consistently and deliberately violated these obligations, while Israel's conduct in relation to UNRWA long predates the armed conflict that began in Gaza on 7 October 2023. Its attacks against UNRWA during the war remain unprecedented. Israel has attacked and destroyed UNRWA premises, property, facilities, and has targeted, detained, and ruthlessly killed UNRWA personnel. On 13 October 2023, Israel issued an order for UNRWA to evacuate its headquarters in northern Gaza and imposed access restriction on humanitarian operations from the new premises on Rafah on security grounds. This has resulted in numerous denials of UNRWA humanitarian missions. Mr. President, there can be no security-related justification to these violations. The General Convention does not admit to any derogation from its positions. It applies fully in all circumstances and contains no limitations for requirements of military expediency or security. Israel has also sought to justify its action on the grounds of allegations of UNRWA's purported lack of neutrality. These obligations have been disproven by the independent review group appointed by the United Nations Secretary General, which confirmed UNRWA's long-standing commitment to neutrality while proposing measures to further advance such neutrality, taking into consideration the challenging operational environment. The agency has held that Israel is capable and indeed responsible for alerting UNRWA to any security-related concerns regarding personnel, which should be addressed in cooperation with the agency in a manner consistent with UNRWA's status and immunities. Honourable members of the Court, I thank you for your kind attention, and now I would like to ask you, Mr. President, to call upon Councillor Dr. Jasmine Musa to take the floor. Thank you.
I thank Mr. Abdelkader. I now give the floor to Ms. Jasmine Musa. You have the floor, Madam.
Thank you, Mr. President. Distinguished members of the Court, it is a privilege to appear before you once again and an honour to be representing the Arab Republic of Egypt. Allow me to turn to the second part of Egypt's submission, namely Israel's obligations as an occupying power to ensure and facilitate the unhindered provision of urgently needed supplies as well as humanitarian and development assistance. For decades, the Palestinians in Gaza have endured Israel's land, sea, and air blockades, its border closures, its restrictions on the movement of people and goods, in what has been described as the largest open-air prison in the world. These measures have been found by the UN Special Rapporteur on the situation of human rights in the OPT to constitute a form of collective punishment. As the current siege of Gaza, and the worst yet, enters its 8th consecutive week, Palestinian civilians are facing soaring levels of need. Over 2 million people have been plunged into a man-made famine engineered through the Israeli blockade. With Israel's resumption of its indiscriminate hostilities, no place in Gaza is safe. Reports bring chilling accounts of the deliberate targeting and killing of civilians, whether in so-called humanitarian zones, in refugee camps, in hospitals, in their homes, and while they're waiting for aid. This cruel and callous disregard for human life and dignity is ongoing, even as we stand here in this great hall of justice. Israel's weaponization of humanitarian aid has created a humanitarian catastrophe of epic proportions. The UN has called Gaza a humanitarian nightmare, where aid is being used as a bargaining chip and a weapon of war. The Independent International Commission of Inquiry on the OPT reported that explicit public statements by Israeli officials indicate an intention to instrumentalize and weaponize the provision of necessities in order to hold the population of Gaza hostage to achieving military and political objectives, including the forced displacement of civilians. Since December 2023, the UN Secretary-General has warned of the risk of total collapse of the humanitarian support system, and consequently the breakdown of public order and increased pressure for mass displacement into Egypt. The beleaguered people of Gaza are once again caught between a rock and a hard place, to either stay and endure death, destruction, hunger, and disease, or to leave behind their lawful homeland. Israel's total war is a means to achieve a far more insidious end, the removal of Palestinians from their land and their extermination under the fog of war. This is undeniably Israel's war aim, embedded in its systematic policies to deprive the Palestinians of food and decimate their hospitals, to deny access to and discredit international independent humanitarian actors, to seize and fragment massive areas of land under the pretext of so-called security zones, and to expand colonial settlement activity in the West Bank, eroding the basis for the two-state solution. Distinguished members of the Court, I will focus my statement on 4 main points. First, the applicability of occupation law to the entire occupied Palestinian territory, including the West Bank, including East Jerusalem and Gaza. 2, Israel's obligations under jus in bello, specifically occupation law, not to hinder or obstruct humanitarian assistance. 3, Israel's obligation under international human rights law not to hinder or obstruct humanitarian and development assistance, and to facilitate early recovery and reconstruction while the Palestinian people remain in their land. And finally, I will conclude with the legal consequences and a summary of Egypt's submissions. Mr. President, Egypt respectfully submits that the obligations of Israel, the occupying power, apply in the entirety of the Palestinian territory occupied in the 5th of June 1967 war, namely the West Bank, including East Jerusalem, and the Gaza Strip, which constitute a single territorial unit. In determining whether a territory remains occupied, this Court has observed that the decisive criterion is not whether the occupying power retains physical military presence, but rather whether its authority has been established and can be exercised. Based on this, the Court concluded that after its so-called disengagement, Israel remained capable of exercising and continued to exercise certain key elements of authority over Gaza, and consequently to have obligations under the law of occupation commensurate with its degree of effective control. It is undeniable that Israel continued to retain control over Gaza, including its airspace, its territorial waters, its civilian infrastructure, and by assuming key governmental functions. Through the Coordinator of Government Activities in the Territories, or COGAT, Israel exercises control over the entry and exit of goods and people into and out of Gaza. Such control has only been further consolidated since Israel's brutal offensive against Gaza, launched on the 7th of October 2023. Mr. President, there is nothing in the jus in bello to preclude the continued application of occupation law while hostilities persist, or where local authorities continue to exercise their functions, contrary to what some states have argued during these proceedings. In fact, many provisions of GC4 presuppose the existence of hostile acts against the occupying power, or expressly require cooperation with local and national authorities, for instance, in the area of healthcare and education. It flows from this that Israel is obliged, as an occupying power, to comply with a range of obligations embodied in GC4 in the Gaza Strip, as well as the entire OPT, including East Jerusalem. Distinguished members of the Court, I now turn to Israel's obligations under jus in bello to ensure and facilitate the unhindered provision of urgently needed supplies and humanitarian assistance. From the beginning of the Gaza crisis, Israel has choked the flow of humanitarian aid, despite numerous Security Council and General Assembly resolutions, as well as orders of this court demanding protection of civilians and the unhindered provision at scale of urgently needed basic services, humanitarian necessities, medical supplies, and medical care, including by increasing the capacity and number of crossings. Egypt, for its part, has been steadfast in its commitment to facilitate the entry of aid through its territory. Since the onset of the crisis, Egypt received 903 airlifted consignments and 557 sea shipments of aid. It facilitated the entry of more than 35,000 trucks carrying 534,000 tons of aid. Egypt also facilitated almost 700 fuel trucks, 176 ambulances, and received thousands of wounded Palestinians and their families. The Security Council welcomed Egypt's efforts to facilitate the use by UN humanitarian agencies of the crossing at Rafah, once the lifeline of humanitarian aid into Gaza. Time and again, Egypt's efforts have come up against ongoing Israeli impediments. First, Israel denied humanitarian access altogether by closing all its crossings into Gaza, bombarding the Rafah crossing on the Palestinian side and blocking the flow of aid. After immense efforts from Egypt and the international community, the Rafah crossing was reopened on the Palestinian side on the 21st of October 2023 and the Karma Busailim crossing on the 16th of December. However, Israel continued to impose measures to significantly restrict the flow of goods and aid entering Gaza. Second, Israel's creation of legal, administrative, and other hurdles through decreeing that all humanitarian aid trucks passing through Rafah were to be inspected at the Israeli crossing in Nitzana, some 47 kilometers away, severely and purposely delaying and hampering the entry of trucks and blocking life-saving humanitarian items due to multiple rejections. Third, Israel's direct attacks on humanitarian infrastructure, including the crossing itself. On 7th of May last year, Israel launched its military offensive against Rafah, a refuge for more than 1 million Palestinians and the hub for humanitarian assistance to Gaza, severely impacting humanitarian operations. Israel attacked the Rafah crossing, a decidedly civilian object, rendering it inoperable. Humanitarian agencies were forced to withdraw, all the time while the crossing remained open on the Egyptian side. As the flow of assistance through the Rafah crossing was blocked, Egypt continued to facilitate humanitarian assistance through the Karma Busailim crossing. Fourth, Israel failed to prevent the looting of humanitarian aid consignments and attacks by Israeli settlers. Israel has deliberately targeted aid convoys and aid seekers in mass killings of an unprecedented scale, as well as willfully targeting and destroying Gaza's health infrastructure. In the latest escalation, Israel closed off all crossings into Gaza and resumed active hostilities in breach of the ceasefire brokered by Egypt, Qatar, and the United States. No humanitarian supplies have entered Gaza since the 2nd of March, piling up at crossing points and cutting off more than 2 million civilians from their means of subsistence, effectively killing them slowly. Mr. President, Israel's policy of willfully impeding relief supplies and obstructing the work of humanitarian actors, including UNRWA and other UN agencies, violates a number of international obligations, including the customary international law principle of respecting and protecting humanitarian workers, and the prohibition of attacking, destroying, or rendering useless objects indispensable for the survival of the civilian population. The obligation under Article 55 GC4 to ensure the food and medical supplies of the population if the resources of the occupied territory are inadequate. The obligation to take all measures to ensure public order and safety and maintain the legal order of the occupied territory. The obligation under Article 59 to agree to relief schemes if whole or part of the population is inadequately supplied and to facilitate such schemes by all means at its disposal. The obligation under Article 61 to facilitate the rapid distribution of relief consignments with the cooperation and under the supervision of the protecting power or a delegated neutral party such as the ICRC or other impartial humanitarian organization. And finally, the prohibition of starvation of the civilian population. To justify these egregious violations, Israeli officials have invoked...
Madam, I'm sorry to interrupt you. Could you speak more slowly to facilitate the work of the interpreters? Thank you.
Thank you, Mr. President. To justify these egregious violations, Israeli officials have invoked security concerns and claims of aid diversion while conditioning the flow of aid on the terms of the ceasefire. There can be no possible moral or legal justification for the prolonged siege and starvation of more than 2 million civilians. By its indiscriminate nature, it simply cannot conceivably constitute a legitimate military objective. In addition, the occupier's obligations under Article 55 to ensure and bring in the necessary food and medical supplies is unqualified. The occupier must also agree to and facilitate relief schemes by impartial humanitarian organizations, including ICRC and third states. Distinguished members of the court, what purpose could IHL possibly serve if it can be overridden by the whims of the occupying power? Security and military necessity are already considered in the formulation of the discussed provisions of GC4, which do not envision an exception for military necessity. Israel's denial of humanitarian aid to civilians in need is thus indefensible and clearly indicates an intention to starve the civilian population rather than to achieve any purportedly military objective. Not only has Israel completely defied its obligations under GC4, it has made a mockery of international law by seeking to replace impartial UN and other humanitarian organizations with its own so-called civilian relief mechanisms. This completely defies the purpose of IHL, which seeks to direct relief to the needy population and not the occupying power, and to insulate humanitarian relief from political, military, or other objectives. Replacing international humanitarian actors with an Israeli mechanism cannot but serve to further Israel's agenda to expel the Palestinians from their land and change the demographic composition of the OPT. As already confirmed by this court, any change in the demographic composition of the OPT violates Article 49 of GC4, which prohibits individual or mass forcible transfer. The court has concluded that transfer may be forcible not only when achieved through physical force per se, but when the people concerned, and I quote, have no choice but to leave. Egypt strongly denounces all policies intended to effect the expulsion, displacement, transfer, or deportation of Palestinian civilians, whether inside the OPT or to other countries. Mr. President, I now turn to Israel's obligations under international human rights law, which, as confirmed by this court, is applicable to the OPT. Not only is Israel's deliberate obstruction of humanitarian relief a breach of a slew of fundamental human rights, but its obligations also extend to rebuilding Gaza. Israel has wrought death, destruction, and suffering upon Gaza on a massive scale. The people of Gaza have no homes to return to, no infrastructure, no basic services. An immediate return to the ceasefire is critical if Gaza is to have any hope for recovery. Israel is also bound to facilitate and not impede regional and international reconstruction efforts in Gaza, while the Palestinian people remain in their own territory in accordance with their right to self-determination. Israel must also refrain from obstructing the consolidation of Palestinian state institutions and enable the Palestinian Authority to resume responsibilities in Gaza and consolidate a viable and contiguous Palestinian state on the pre-1967 lines with East Jerusalem as its capital. Mr. President, I will conclude with the legal consequences and a summary of Egypt's submissions. Egypt respectfully submits that the court should advise the General Assembly that, number one, Israel's prolonged occupation remains a continuing violation of international law, and until such time as the occupation ends, Israel is bound to respect its obligations as an occupying power throughout the entire OPT. Two, Israel, as the wrongdoing state, is obliged to make full reparation through restitution, compensation, and satisfaction, either singly or in combination, by ceasing immediately and unconditionally its unlawful conduct, including lifting the siege imposed on civilians in Gaza and ensuring the essential supplies of the civilian population, refraining from indiscriminately targeting civilians, humanitarian, and medical personnel, implementing Security Council Resolution 2735 without delay, and the ceasefire agreement brokered by Egypt, Qatar, and the United States. Fully withdrawing from the Gaza Strip and enabling the Palestinian Authority to resume responsibilities in Gaza, including border control. Agreeing on relief schemes on behalf of the Palestinian civilian population and facilitating them by all means at its disposal. Allowing unrestricted, unobstructed, and safe humanitarian access at scale and in a timely manner through all entry points. Refraining from any measures and practices to expel, deport, displace, or transfer Palestinians from the territory occupied in 1967. Refraining from obstructing the presence and activities of the UN and its agencies, including UNRWA, as well as third states providing humanitarian assistance, and repealing the unlawful laws related to UNRWA, as well as upholding the agency's privileges and immunities. Egypt respectfully calls on the court to declare that the Palestinian people's right to self-determination entails their right to remain on their territory and to pursue their economic, social, and cultural development on that territory, the territory occupied unlawfully by Israel in 1967, namely the Gaza Strip and the West Bank, including East Jerusalem. This includes the right to receive development assistance for early recovery and reconstruction without being displaced or expelled from their land. Mr. President, the credibility of international law, indeed the credibility of the international system itself, is at stake. Egypt respectfully requests the court to assert its authority and pronounce itself on the General Assembly's urgent request in the interest of peace and justice for the Palestinian people and the entire Middle East. I hereby conclude Egypt's submission. Thank you.
I thank the representatives of Egypt for their presentation. I now invite the next participating delegation, Malaysia, to address the court, and I call upon Her Excellency Dato Sri Azalina Osman Said to take the floor. You have the floor, Madam.
Bismillahirrahmanirrahim. Mr. President, distinguished members of the court. It is an honor for Malaysia to appear again before the court in these advisory proceedings, yet it is a somber honor. We come not merely as a member of the United Nations, but as a voice echoing the pain of a people whose rights, homes, and future are being dismantled before the eyes of the world. The question before the court is a grave one. What are the obligations of an occupying power and of a member of United Nations that continues without regard for international law or human decency to obstruct, undermine, and dismantle the very systems built to preserve human life and dignity in the occupied Palestinian territory? A little over a year ago, Malaysia was addressing the court on the policies and practices of Israel in the OPT. Unfortunately, the situation in the OPT has deteriorated even further since that day in February 2024. What was then widespread devastation has now evolved into openly declared, brutally enforced, and tragically ignored outright displacement and destruction. In the last few weeks, we have witnessed not only a renewed offensive against the Palestinian population in the Gaza Strip and the West Bank, but also statements by senior Israel officials that leave no doubt Israel's intention is to bring about the ultimate denial of the Palestinian people's right to self-determination through their eventual displacement and elimination. Just in these last few weeks, Israel Defense Minister Katz has on 2 occasions admitted openly that the target of Israel operation is in the civilian population of Gaza.
I'm sorry to interrupt you, but could you please speak more slowly?
Yes,
of course. To facilitate interpretation.
I will try, Mr. President. On 19 March, Katz addressed a final warning to the residents of Gaza. The Air Force strikes against Hamas, he said, were just the first step. It will become much more difficult, and you, the residents of Gaza, will pay the full price. Katz continued, return the hostages and remove Hamas, and other options will open for you, including leaving for other places in the world for those who want to. The alternative is absolute destruction. Again on 2nd April, Katz posted on Twitter X, the goal of Operation Strength and Sword is first and foremost to increase pressure for the release of all hostages. But the goal is not to increase the pressure just on Hamas, Mr. President. According to Minister Katz, the goal is to increase the pressure also on the population in Gaza. Katz finished his post by calling on the residents of Gaza to act now to remove Hamas and return all the hostages. This is the only way to end the war. Threatening the civilian population of Gaza with destruction unless they remove Hamas and return the hostages, an objective that even Israel, with all its military might, has not even come close to achieving in over a year and a half of merciless killing and maiming. This demonstrates Israel's intention is in no uncertain terms. Israel's allies themselves confirmed this before Israel's violation of ceasefire, when they stated in February that Gaza is hell, a pure demolition site, and not a place for people to be living. According to such Israel allies, Palestinians have experienced nothing but death and destruction, and their return to Gaza is a guarantee that they are going to end up dying. What more is there to be said as to the objective that Israel is pursuing, Mr. President? Even before it shattered the ceasefire and renewed its offensive on 18 March, Israel imposed a total blockage on the humanitarian relief destined for Gaza, closing all border crossings and completely cutting off the electricity supply into the Strip. The stated aim of these unlawful and inhuman measures was to exert pressure on Hamas to accept changes to the already agreed upon ceasefire. This demonstrates Israel's control as an occupying power over life and death in the Strip. It also brings the subject matter of the request for an advisory opinion currently before your court into sharp relief. These Israel measures have been taken following Israel's passage of legislation purporting to ban the operation of the United Nations Relief and Works Agency for Palestinian refugees in Near East, both in Israel and in the occupied Palestinian territory. Malaysia is saddened, but unfortunately not surprised. To add all this has been happening is the face of provisional measure orders handed down by the court in case brought by South Africa against Israel, and in the face of the advisory opinion of 19 July 2024. It is typical of Israel to ignore its international obligations and the decision of this court, the principal judicial organ of the United Nations. And yet, we are here to try and to get some clarity on the obligations of Israel as an occupying power and as a member of the United Nations as this relate to the OPT. The authoritative statements of these obligations by the court will greatly assist the General Assembly in its effort to bring to an end, in accordance with the court's advisory opinion, as mentioned, Israel's unlawful occupation of the OPT. Malaysia's submission today is straightforward. It builds upon its submission and the court's advisory opinion of 2024. It can be essentially distilled into the following arguments. 1. The obligations of Israel as an occupying power, as they have been detailed in the Malaysian's written statement as they will be summarized in our presentation today, are established to accord protection to a people under foreign occupation. Second, the obligation of Israel as a member of the United Nations are established in pursuit of the organization's purpose to develop friendly relations among nations based on respect for the principle of equal rights and self-determination. Third, the recent policies and practices of Israel, especially with respect to UNRWA, do not only constitute violations of its obligation as an occupying power and as a member of the United Nations. Rather, taken together, they are also in serious breach of each of the four aspects of the right to self-determination of the Palestinian people. As these were detailed by the court in its advisory opinion of 19 July 2024, in this presentation, we will first deal briefly with the court's jurisdiction and its discretion to respond to the request of the General Assembly. In the third part of our presentation, we will summarize what Malaysia submits are the obligations of Israel as the occupying power and a member of the United Nations in relation to the OPT, especially with respect to the operation of UNRWA. In the final part of our presentation, we will demonstrate how the policies and practices of Israel in this respect not only violate the obligations that we have summarized, but constitute a grave breach of the right of the Palestinian people to self-determination. Mr. President, members of the court, allow me to be brief when it comes to your jurisdiction and the exercise of your discretion in the present request for an advisory opinion. With respect to jurisdiction, it appears obvious to Malaysia that the General Assembly is competent to submit this request, and that the request for the court to give its opinion on a legal question. In particular, the question is for the court to set out the obligations of a state under international law in a particular context. It is thus a question framed in terms of law and raising problems of international law, thereby being, by its very nature, susceptible to a reply based on law. As regards the court's discretion, it is Malaysia's submission that there are no compelling reasons for the court to decline the exercise of its jurisdiction in the instance. There are no such reasons anymore than there were in the Wall opinion, or indeed in the opinion of 19 July 2024, of which this request can be seen as an extension. What led to this request is indeed the adoption of Israel's policy and practices in the OPT, as this relate to the UN, other international organizations, and the third state. What is more, the purportedly compelling reasons invoked by some states in their written statements, such as the Eastern Karelia Principle, the alleged insufficiency of factual information before the court, and the complexity of the situation in the Middle East, have been pleaded before this court time and time again in similar circumstances and have been consistently rejected. Malaysia respectfully submit that there is no reason for the court to diverge from this constant jurisprudence. Mr. President, members of the court has already found that the OPT constitute a single territorial unit and that Israel has obligation as an occupying power of that whole territorial unit, obligations which are commensurate with the degree of its effective control over it. This effective control is today complete, including over the Gaza Strip, as our introductory references to Israel's total cutting off humanitarian aid and electricity in Gaza have demonstrated. As the occupying power over the whole of OPT, Israel is under a matrix of obligation which emanate from international humanitarian law and international human rights law. The latter remains applicable even during armed conflict. As the court has consistently found, Malaysia will not go through these obligations here. We respectfully refer the court to Malaysia's written statement which set out these obligations in some detail. Malaysia will, however, provide a general structure of the matrix of obligation incumbent upon Israel as the occupying power. The matrix is construed by relevant provisions, which is the Hague Regulation of 1907, the Fourth Geneva Convention of 1949, and the First Additional Protocol of 1977. These reflect not just international customary law, but intransgressible principles of international customary law Malaysia submits. They are supplemented by obligations under international human rights law. Taken together, these obligations establish that Israel, as the occupying power, must administer the OPT for the benefit of the local population. Israel is under a set of positive obligations to ensure that the civilian population in the OPT is adequately provided with food, water, shelter, clothing, fuel, energy, and generally all the necessities of life, along with educational and health services. In parallel, Israel is under a set of negative obligations not to hinder or interfere with the operation of health and education services or with the operations of humanitarian organizations in the OPT. If the civilian population is inadequately supplied, which in our case there is no question that it is, then the matrix of obligation incumbent upon Israel requires it to agree to and to facilitate relief schemes, including by impartial humanitarian organization to facilitate distribution of relief consignments, and to guarantee the protection of such relief and the relevant humanitarian personnel engaged in its transport and distribution. It is Malaysia's submission, Mr. President, that Israel is in clear breach of this whole matrix of obligation of an occupying power. Israel has not only kept the OPT chronically undersupplied, adding insult to injury, it has been consistently draining it of its resources, such as they are. Or it has been wantonly destroying them, along with facilities dedicated to education and health. Most recently, Israel has legislated to ban the operation of UNRWA in the OPT, essentially stopping the only humanitarian organization that has assumed comprehensive responsibility for the provision of the civilian population. And he has now completely blocked any humanitarian aid and electricity to Gaza as well, as we have already reported. But Malaysia has one further submission to make this connection, Mr. President. That is, UNRWA functions as a humanitarian substitute of the protecting power under international humanitarian law. As Additional Protocol 1 reminds us, the system of protecting power is compulsory. It's not merely an option. In the absence of protecting power or an official substitute, Israel as the occupying power is under an unconditional obligation to accept the offer of a humanitarian organization to function as a humanitarian substitute. It is the United Nations acting to UNRWA that has been operating as a humanitarian substitute of protecting power in the OPT since inception. And certainly since the exchange of letters of 14 July 1967 with respect to Israel. Israel had no latitude to refuse the offer of UNRWA to undertake the humanitarian functions provided for in the Fourth General Convention with respect to the OPT, Fourth Geneva Convention with respect to the OPT. And Israel cannot validly withdraw its consent with respect to UNRWA's humanitarian operations. and its purpose to do through its law to cease UNRWA operations unless it requests or accepts the offer of another humanitarian organization within the 2-month time limit understood to be prescribed by the 4th Geneva Convention for that purpose. Mr. President, members of the court, Israel has been a member of the United Nations since May 1949. It bears a set of obligations under the UN Charter, as well as under the 1946 Convention on UN Privileges and Immunities. A number of these obligations relate to the present activities of UN, including UNRWA as a subsidiary organ of the General Assembly, in and in relations to the OPT. With your permission, we will provide an overview of the content of this obligation, which, as with this obligation of Israel as an occupying power, have been set out in some detail with Malaysia's written statement. As a member of UN, Israel is under an obligation to accord the organization, which self-evidently can only operate through its organs, the necessary legal capacity in its territory, so as to enable the exercise of UN functions and the achievement of UN purpose. It is also under an obligation to respect the organization and its officials' privileges and immunities. And these are set out in the 1946 Convention. In particular, the obligation covers the premises, property, assets, and archives of UN, and the protection granted is absolute. Further, any alleged violation on the part of UN of its own obligations cannot lead to a loss or withdrawal of such protection, but only to the invocation of the responsibility of the UN in accordance with international law. UN officials, including all UNRWA staff, except locally recruited staff that is assigned to hourly rates, also enjoy the protection of Article 105 of the Charter and of the relevant provisions of the 1946 Convention. Finally, the combination of the provisions of Article 1, Para 3, Article 2, Paragraph 2, Article 2, Paragraph 5, 55, and 56 of the Charter clearly establishes an obligation for Israel to cooperate with the organization in good faith in striving for economic, social, health, cultural, education, and humanitarian development. Israel must cooperate with the UN to ultimately achieve respect for human rights, as well as equal rights and self-determination of people. It is clear to Malaysia, Mr. President, that Israel's adoption and implementation of the law to cease UNRWA operations and of the law to cease UNRWA operations in the territory of the State of Israel put it in direct breach of this obligation. These pieces of legislation essentially aim to deprive UNRWA and through it the United Nations of its legal capacity in territory that Israel controls. They prohibit the operations of UN officers in breach of privileges and immunities of the United Nations. They have led to the non-renewal of work visa for UNRWA international staff that were forced to leave the OPT in January 2025, and to threat of criminal proceedings against UN officials in breach of their privileges and immunities. And ultimately, they egregiously violate Israel's obligation to cooperate with the organization in good faith. This is on top of all various other policies, practices, and conduct of Israel in breach of this obligation, ranging from the destruction of UN property and premises, including UNRWA schools, health clinics, and vehicles, to measures taken against the UN Secretary General, to the willful and persistent disregard of the decision of this court. In concluding to this section of Malaysia's presentation, Mr. President, we would like to make one more point. It is Malaysia's submission that Israel cannot validly terminate the 1967 exchange of letters unilaterally. This is because, under its own terms, the agreement between Israel and the UN remains in force until replaced or cancelled. Replacement or cancellation must take place by mutual consent. As this court has found in its advisory opinion on the agreement between WHO and Egypt, any modification to or termination of such an agreement needs to be negotiated in good faith between parties. Mr. President, members of the court, the obligations we have set out are ultimately meant to support and entrench the right to self-determination. The rules of international humanitarian law do so by according protection to a people under foreign occupation. The rules of UN Charter and the 1946 Convention do so by according protection to the United Nations in its pursuit of its purpose of developing friendly relations among nations based on respect for the principle of self-determination. Ultimately, Mr. President, Malaysia's argument boils down to this. The recent policies and practices of Israel towards the United Nations, and in particular UNRWA, taken together, constitute violations not only of the obligation we have sketched out already, but also of each of the 4 aspects of the right to self-determination that the Court identified in its advisory opinion of 19 July 2024. First, with respect to the right of territorial integrity as a corollary of the right to self-determination, the laws purporting to cease the operations of UNRWA, along with the administrative measure pursued against UNRWA premises, are a further step in the entrenchment of the ongoing annexation of the occupied Palestinian territory. The attempt by Israel Land Authority to seize UNRWA premises reportedly in order to construct 1,440 housing units is typical of Israel, conduct found to constitute annexation by the court in its advisory opinion of 19 July 2024. Second, with respect to the right of the people to its integrity, the cessation of the operation of UNRWA, which provides education through a large network of schools, primary health care through a large network of health clinics, and vital supplies through an extensive distribution network, is calculated to force the departure of Palestinian populations from the affected areas, which essentially include all the occupied Palestinian territory. This is evident now more than ever, and especially in Gaza. Third, with respect to the right of permanent sovereignty over natural resources. The expulsion of UNRWA is calculated to cause a humanitarian catastrophe, given that Israel has been exploiting the natural resources of the OPT for its own benefit and for the benefit of illegal settlements for decades. The natural resources of the West Bank have been depleted, and the Gaza Strip has been reduced to rubble. Removing the lifeline of UNRWA will signal the ultimate collapse of the OPT's ability to sustain itself. The Palestinian Authority has already made it clear that it does not have the financial resources or capacity to compensate for the loss of the UNRWA services. Fourth, with respect to the right of the people freely to determine its political status and to pursue its economic, social, and cultural development, the expulsion of UNRWA with the concomitant cessation of operation of its schools, its clinics, humanitarian relief, development assistance, microfinance and micro-enterprise schemes, and other programs will lead to further deterioration of the Palestinian people's ability to enjoy even basic human rights, to educate themselves, and to hope to build a future in their own sovereign state. States undertake obligation not as a rhetorical gesture, but with a view to achieving certain ends. Malaysia submits that the obligation assumed by occupying powers and by members of the UN have as their ultimate end the protection of people from extinction and the safeguard of their right to self-determination. Mr. President, this concludes Malaysia's submission today. Malaysia thanks the court for its kind attention. We also thank the Secretariat and the interpreters for their diligent work. And I do apologize if I was running very fast. Before I end, before I sit down, Mr. President, let me end with a quote from Plato: "The worst form of injustice is pretended justice." Thank you so much.
I thank the representative of Malaysia for her presentation. This concludes this afternoon's sitting. The oral proceedings will resume tomorrow at 10 a.m. in order for South Africa, Algeria, Saudi Arabia, Belgium, and Colombia to be heard on the questions submitted to the court. The sitting is closed.